plaintiffs' mills that file lawsuits, and they're going to catch on to this and start filing lawsuits against anybody who advertises something that they think this law doesn't allow you to advertise anymore.
And maybe with that we can switch over to the minor marketing case that we have, which is Junior Sport Magazine versus Bonta. This was basically the lawsuit that came out against AB 2571. The quick history here is that the law was passed. We filed a lawsuit, and then they came back and did an amendment to that law, which was AB 160. The last that I had checked, we had filed for a preliminary injunction, which was not granted by the judge. What do we have to look forward to in that case?
We've already filed our appeal to the Ninth Circuit. We're recruiting Second and First Amendment experts and scholars to submit amicus briefs with us. There's some fairly significant issues in there about the distinction between political or commercial speech, what kind of protections various different types of speech are entitled to. But I'm very hopeful that we will prevail in the Ninth Circuit. The Ninth Circuit's kind of in a bind. They're usually very protective of First Amendment rights, and they may not like the speech, that this bans, which is essentially, come learn the shooting sports. It's fun. You should go hunting. You should learn to target shoot, and it's a great family experience. It's really kind of shocking. I guess I shouldn't say that. It's not shocking that Newsom would push this, because it's part of his effort to ban the gun culture. He doesn't want juniors to be able to, kids to be able to be brought into the shooting sports and find out how much fun they can have at the range or in the field. But we're on appeal, very confident in our arguments, and we think the Ninth Circuit will turn it over. And if we have to, we'll go to the Supreme Court.
Well, definitely looking forward to that one too. I want to focus quickly though on the amendments that were made, which is AB 160. What was the purpose of them bringing those amendments to the law? I understand that they created exemptions that may have been murky from the law itself. The law still seems pretty murky. Obviously, there's been nobody who's been fined for this yet, so it's hard to tell. But what is worth continuing on this lawsuit, even though those amendments have been made?
There's still plenty of speech that is banned, and there's a lot of speech that we're not sure if it's banned or not. And remember what the danger of this particular law is. It creates a private right of action. So anyone can sue you if you put a magazine out in the state of California that has some ad that's designed to get juniors to the range. You can be sued by the Brady Center or any gun control group or any private person. They can sue you for that, and it's $25,000 per incident. There's a big fine for every incident. Now, remember, the Brady Center and like Everytown for Guns and all those groups, they are very organized in recruiting people to file lawsuits. That's part of their strategy. They file lawsuits against gun manufacturers all the time. They would like to bankrupt the gun manufacturing industry. And remember, gun manufacturers make in a year what tobacco makes in a day. They can't fight as hard and as long as tobacco has. But they want to make this a legal mill, where there could just be lawsuit after lawsuit after lawsuit filed, and any ambiguity in the law, the lawyers for Everytown are going to say, well, we'll let the court figure that out. You pay your attorney's fees to defend against this law. Well, we claim that what you did was banned, and you say, no, it's covered by some exemption, but it's not clear. And then you're going to have plaintiffs' lawyers. Remember, there's plaintiffs' lawyers out there who go after Prop 65, the warning labels you're supposed to have, or you don't have the right wheelchair ramp into your store, or your website is not designed to be viewed by people with handicaps, whatever. There's these plaintiffs' mills that file lawsuits, and they're going to catch on to this and start filing lawsuits against anybody who advertises something that they think this law doesn't allow you to advertise anymore. So there's a lot of unanswered questions and a lot of risk involved for anybody who's trying to put these events on in California. And that needs to be taken care of. That needs to be addressed and hopefully struck down so that we don't have to run that risk anymore. We don't have to worry about some organized plaintiffs group trying to put a gun range out of business or a junior shooters group out of business.
And these fights are going to continue. Every single one of these lawsuits, every single one of these programs, every time CRPA is fighting up in Sacramento, it's being done on your behalf. So if you could, please hit the subscribe button, hit the like and share button. We're trying to get this out to as many people as possible to let them know that they are being fought for when it comes to their Second Amendment rights. Thanks, guys, again, and we'll see you on the next one.